Good morning, all. Good morning, Lavanya ma'am.
Good morning, ma'am.
Can we start?
Yeah.
Amira ma'am?
We'll start.
Okay. Good morning, all. Welcome to the online platform organized by the Department of Commerce and Management Studies in association with the IPR Cell, Kabila, IIC and IEDC of MAS Pannani College under the National Intellectual Property Awareness Mission, Government of India. Today, we are organizing this function to provide an awareness to our students regarding the intellectual property and their rights. National Intellectual Property Awareness Mission is an initiative started by Government of India in December 2021 to provide awareness to the students regarding the intellectual property and its rights, and it aims to inculcate creativity and innovation among the students of higher education. Today, we have a very eminent resource person, Ms. Lavanya Maduri, with us to handle the session on intellectual property rights and trademarks. Welcome, ma'am, to this function.
Thank you, ma'am. Thank you.
Let me move on to my duty. First of all, I would like to welcome our beloved principal, Dr. Amira VU, the principal of MAS Pannani College, to preside over this function. Welcome, ma'am.
Thank you.
I would like to introduce our resource person to you. Ms. Lavanya is a electronic and electrical engineering graduate, and he is an official trainer from Google and Microsoft. She's working with NIPAM for the last few years and is handling many sessions on intellectual property to the students of colleges and universities in South India. Welcome, ma'am, to this function. Then I welcome the IPR cell coordinator, Ms. Soumya CC, the IIC coordinator, Dr. Jairam, and the IEDC nodal officer, Ms. Nusrat, and all other faculties of the Department of Commerce and Management Studies and to students from other institutes and other faculties from other institutes to this function. Let me hand over this platform to Dr. Amira VU for the presidential address. Thank you.
Respected Chief Guest, Ms. Lavanya Maduri, IPR Cell Coordinator Soumya, Program Coordinator Rahina, faculty members, and my dear students, a very good morning to all. First of all, I would like to appreciate Ms. Soumya, IPR Coordinator, and the Department of Commerce and Management Studies, IIC and IEDC for organizing the webinar. Here, discussion is going to be held on an important topic that affects all of us, intellectual property rights and trademarks. As future professionals and entrepreneurs, it is important that our students understand the significance of these concepts and the role they play in the world of business. As students, you may be creating your own intellectual property as part of your coursework, research, or personal projects. By understanding how intellectual property rights work, you can ensure that your work is protected and that you receive the recognition and compensation you deserve in your efforts. As you embark on your academic and professional journey, I encourage you to learn more about these concepts and their applications. By doing so, you can ensure that your ideas and creations are protected and that you can build a successful career in your chosen field. And here we have an expert guest who can talk more on the subject. As mentioned in the welcome note, Lavanya Maduri is NIPAM Officer of Government of India. I too would like to extend a warm welcome to her. She will elaborate on the topic. Over to you, madam.
Thank you, ma'am. Thank you for the warm welcome. And good morning, everyone. Warm welcome to you for this session. And I hope my slides are visible. Can anyone confirm it? Are the slides visible?
Yes, ma'am, it's visible.
Okay, thank you. So this session is about the awareness of intellectual property and its rights to the students, as briefly introduced by the ma'am already. Yeah. So we also collaborated with Kapila. Kapila is another scheme for filing for the intellectual property. So this session is collaboration of NIPAM and Kapila. So please have a quick glance of this slide. So it states that no part of this session will be reproduced without the permission of our office. And brief introduction of me is I work as a patent examiner. So my role is to examine the patents related to electrical field. So I mostly examine the patents related to electrical engineering, electronics, communication, and computer science. So I work under the guidance of patent law under 1970. So it's most like a techno-legal job. So in this session, I will be giving the brief idea of what is intellectual property and what are the types of intellectual properties and what are the intellectual property rights and how we can differentiate each intellectual property that happens around us. And we can I will give a brief idea about the patent filing procedures. So before entering into the main session, let's see how the intellectual property is happening around us. So you all might have seen in the newspapers that Facebook has changed its name to Meta. So actually, as the world is moving towards the Meta world and Meta technology, Facebook felt that Meta would be more appropriate to their company. So, but Meta is earlier another bank company's name in South Dakota. They cannot directly use the term Meta because the earlier bank has already trademarked the name Meta. So as they cannot take the name Meta directly, what Facebook did is it has paid around $60 million. That is in Indian currency, it is 400 crores. If you see, a Meta is a simple word, 4-letter word, but as the rights are associated with it, the value of the term has increased. This is a simple example related to a trademark. So even though it is a simple word, the rights are associated with it and the value has increased drastically. And this is the most recent example you have seen in your local newspapers also. This is about the plagiarism or copyright infringement related to the Kantara movie. And this issue has been settled. So this is an example of copyright infringement. And this is another example related to patents. So patents is generally for a period of 20 years. So if you get a patent right, you can enjoy the monopoly for a period of 20 years. So after the 20 years, anyone can use the technology. So this is a simple example. Amazon one-click, you might be knowing about this in the e-commerce website. So just by clicking on that buy, you can directly purchase that product instead of giving all your details every time like that. So this is already patented by Amazon and this has been expired. So the 20 years period is expired and now it is in the public domain. Even the other e-commerce websites are also using this technology. So these are simple examples that happen around us so that you can get a brief idea about the intellectual property. So what is intellectual property means? The creation of our brain. Either it can be related to technology or creative work like writing a book, painting, songs, symbols, or designs, anything. The creation of our brain is called as an intellectual property. Like other properties like car or gold, house, even the intellectual property is also considered as a valuable asset. So all these properties like car, gold, or house, land, these are the tangible properties, but intellectual property is an intangible property. So the rights associated with this intellectual property are called intellectual property rights. All the IP rights are territorial in nature. For example, if you get a right for a particular thing, suppose take an example of trademark. If you file for the trademark in India and you get that trademark right in India, registration in India, you can use that, you can get that monopoly, or you can use that trademark only in India. You cannot claim in the other country saying that this is my trademark. These are all the intellectual properties are territorial in nature. So if you get any right in India, you can enjoy those rights only in India. So protect your intellectual property. So by seeing this picture, you might be getting a idea of what is happening here. So if you see the first person, he has created some idea, and the other person has taken away his idea. If he has protected his idea, there is no need of running behind that person. He can simply approach a court or a police station and file a case against the thief. If you don't protect your intellectual property, you have to run behind the thief, and there will be a lot of nobody. It is very difficult to convince people that it is your original idea. So it is always benefit to protect your intellectual property, whatever it may be, like a patent or a design patent or copyright, anything. You have to protect your creations of your brain. So for a simple example, if you have created some idea, a startup idea, you want investors to invest in your business. So you will be going to big companies to invest for the investors. So they will ask for your idea. You will explain that idea, and that big investor will think that you have not protected your idea. So what he will do, instead of investing in your business, he will take your idea without your permission. He will use that idea for his business and become more rich. So if you have protected your idea, it will be more beneficial for you, because you will be getting all the recognition and all the protection for your work. No one can take away your ideas. So it is always beneficial to protect the ideas. Significance of intellectual property. So first I'll start with the simple example called land. So what is the first thing you will do after buying the land? You will go to the register office and get it registered on your name. In the same way, if you have any intellectual property, you have to get it registered on your name. As in the case of the land, after the protection, what you will do, you will place a board saying that this property belongs to so and so person. So in the way, you are excluding other people to enter into your land without your permission. So as same in the case of intellectual property, after getting registered, you can exclude others. So if anyone wants to use your work, they have to take the permission from you. Without the permission, it is called as an infringement. So it is in the simple way, we are excluding others. So if anyone wants to use your work, they have to take your permission. And the third one is utilize, commercialize, earn. So as in the case of the land, after protection, after excluding others, what you can do, you can use that land for your own purpose, for house building or any mall building, or for hospital purpose, or you can use the land for the agriculture purpose, depending on your interest. In the same way, with the intellectual property, you can use it for your own purpose. So you can use that idea to build your business, or you can give it to the other people. So like selling to the other people, or giving license to the other people, or giving completely transferring all the rights to the other people, like that. And you can also get the investors, you can expand your business. So what does intellectual property offer? Means I hope all the slides are visible now, because sometimes people won't see the slides. So what does intellectual property offer means? Due recognition and rewards. So definitely, if you create something, you will get the credibility of you are the creator. For example, if you write a book, your name is published as an author. If you create some technology and you get the patent, you will be the sole inventor of that particular technology. And next one is earn money as royalty, incentives through technology transfer, licensing, etc. So you can build your own business, or you can sell it to the other people and helping other people to build their business. So I can give it as a license to the other people, like that. Commercially sell without fear of copying. Suppose if you take me as an inventor, if I create something and if I go to the market without the protection, I will always have a fear that what if the second person takes my idea? What if the second person, without my permission, uses my methods to develop his business? Like, so if you get the protection, you can completely, without any fear, you can enter the market and develop your products, and you can sell your products. Because even if someone takes your work without your permission, even file infringement suit against that person. That means you can commercially sell the products without the fear of copying. And you can also always distinguish the genuine and the duplicate products also. New innovations happen. Suppose if some technology enters into the market, based on the technology, many innovations happen. Suppose if you take an example of telephone, the first telephone was invented. If Alexander Graham Bell felt that I should not disclose it to the society because society will use it for the wrongful manner, there won't be this much of advancements in the this particular communication industry. So once an invention is developed, based on the innovation, lot of innovations happen. So if you see that telephone has been transformed to many, has gone to many changes, and now we are using it for every purpose. So once a technology invention happens, based on that, new markets, new business evolve. And also, last one is increase the value of college faculty members, students, and also it helps in the economic growth of the country. So types of intellectual property are patents, designs, trademark, copyright, geographical indication, SICLD, and there are some other types of intellectual property. So now we will briefly see the each intellectual property. First one is patents. So if you see this particular statistics, that it shows the number of patents filed in the country in the year 2019. So if you see the top one country is China, it has around 1.4 million patents filed, and India has around 53,000 patents filed in the year 2019. But if you see the percentage change in the from the year 2018, India has improved by 7.1%. So by 7.1%, the patent filing has improved from 2018 to 2019. On the right side, if you see, it shows the GII ranking, that is a Global Innovative Index ranking. So in the year 2015, it is 81. And in the year 2021, it is 46, 22, it is 40. So if you see, there is a huge improvement in the GII ranking of India. This is because as the number of patents filed in a country increases, the image of the country in the global scenario also improves. So the other people in the other parts of the world, other companies think that there is a huge market in India and there is a lot of technology in India. We can use that technology. We can get help from country called India. So as the patent filing increases, the global image of the country also increases. So what is patent means? Patents are given, patents are the exclusive rights given for the invention. For the technical things, we give patents. So suppose if there is some technical problem and you are solving it in a technical way. So for that, you can file for the patent and get the exclusive rights. So with the exclusive rights, you can prohibit other people using your invention. And also the purpose of this patent system, this entire intellectual property system and patent system is developed in such a way that both the inventors, creators, and also the society get the benefit. So if the person who has invested a lot of time and money in his research work, if the government takes away his research or his invention from him and give it to the society, the inventor will be the time invested by the inventor and the money invested by the inventor will go waste. He also should get some return for the work he has done. At the same time, the society also should get the benefit for the work he has done. So the system has been developed in such a way that both the inventors, at the same time society will get the benefit. So the monopoly, the inventor benefits. So for a period of 20 years, so for a period of 20 years, he will be having the monopoly for his work, for his invention, and he can develop the business and also develop the business for this particular, enjoy the monopoly rights for the period of 20 years. So after the 20 years, he will not be having the monopoly. So that after 20 years, it will be in the public domain. So the public small markets or the some MSMEs, they can also use the technologies to develop their businesses. So there is a misconception in the society that patents are given to the most complex inventions. So if you see in this slide, the first one is a baby's hat, that is a patented technology. So the purpose here is to avoid the contact of water and shampoo in the baby's eyes. So to avoid that, they have developed this hat, and they got the patent for this. This is the most simple technology. If you see the other picture, it's an autonomous vehicle. So it will be consisting of most complex technologies and most interdisciplinary technologies related to electrical, electronics, communications, computer science, like that. So a patent can be given to the most complex inventions as well as to the simple inventions. So we'll see some examples related to patents in different fields. So the first one is related to the textile field. So the main problem here is in the problem this particular thing is solving is, so if you are in a seminar hall or if you are in a particular place where you are not comfortable with the environment, surrounding environment. So if I'm in a seminar hall, I might be feeling cold or too hot. So I'll be feeling the discomfort. So what this smart clothing will do is, it will detect my discomfort, and the processor will make the changes in this particular fabric, and so that I will feel the again comfortable. So you can see the patented number below. So if you want, you can search in the Google patents for more information, and you might be identifying this second picture. He is Michael Jackson. So you will be this is the most famous step of Michael Jackson. So generally a person can bend up to 10 to 15 degrees like that. So if you see here, he is bending more than 20 degrees like that. So it will be very difficult for a normal person. The solution is, what he did was, he had made some hole in his shoes, and whenever he moves on a particular place on the stage, a hook will project from the stage and it will get fixed to his shoe. So now his shoe and the ground are in a parallel stage. So and now he's fixed to this particular stage, and he is able to bend more than 20 degrees. He also got the patent for this one, and you can see the patented number below. So the third one is a smart helmet. So the smart helmet is like, whenever the driver takes a right turn, the right side of the helmet will glow, and whenever driver takes the left side, a left turn, the left part of the helmet will glow. Even if some accident happens, this helmet will detect the GPS location and transfer that particular data to the particular data to the emergency contacts. So if you see, these are the first one is related to textile industry, the second one is for the entertainment industry, the third one is for the automobile industry, and this is for the sports. So these are the light glowing stumps, which was developed by the Australian inventor, and he got the patent for that. So as I said earlier, all the intellectual property are territorial in nature. So he is an Australian inventor. He filed for the patent in Australia and got the patent there. So if you see, the cricket is a major sport in many countries like England, New Zealand, in India, etc. So what he did was, if he filed in Australia, he will get patent rights only in Australia. So what he did was, he also filed for the patent in these countries, and he also got the patent. So whenever our BCCI uses these stumps in any cricket match, they will pay some royalty to this particular Australian inventor, that is Australian patentee. So he is getting benefits for his invention not only in his homeland, but also from the other countries. And the next one is a defibrillator. It is related to the medical industry. And next one is a electric car, which is related to electrical electronics industry. So automobile industry. So a patent can be a simple one, complex one. It can be applied to any industry. It is not that it should be related to the technical industry line. It's not like that. It can be belong to any industry like sports, entertainment, medical, anything. So as I said earlier, if you see the telephone, the particular telephone has modified its ways and has developed into a smartphone. So even if you see here that from period of 1982 till now, the mobile phone, not only the technology has changed, even the appearance of the phone has also changed. And a lot of brands emerged in this particular industry. Yes, so there is a lot of evolution in the patent technical field, and also the design, intellectual property, and also the trademarks. So if you take your mobile phone, there will be these number of patents, even the video display or the camera click, touch screen, lock unlock button, all these are the patented inventions. So a simple mobile will be consisting of these many number of patents. So as I said, now a telephone has changed from, has also evolved in the appearance of the product. So if you take a patent, it is for the technology. Suppose if you go for some mobile shop and ask for the most advanced mobile phone, smartphone, the shopkeeper will show you the most advanced smartphone. But if the appearance of the product is not good, you might not be interested to buy that product. So here design plays a important role. Though we are moving towards the advancement of technology, somewhere we are interested in the appearance of the products also. So design is also very important in the intellectual property. So as the companies have identified this intellectual property, so they try to communicate the brand through the designs, and the customer also get connected to that particular company through the appearance of the products. So if you take these two examples, the first one is Domix and the next one is Colin. So nothing is mentioned on these two pictures, on these two bottles, but still we are able to identify these products. So just by the color combinations, shape and design. So we are able to identify the brand, purpose of the product, company name, everything we are able to identify. So design plays a major role in identifying the products by the consumer, and the brand is communicated to the consumer through the designs. So what comes under designs is features of the shape, configuration, composition of lines, whatever it may be, whether it is prepared in an industrial manner or some chemical means or the mechanical manner, whatever it may be, the appearance of the product comes under the designs. Here we are not judging the technical compatibility of the product, we are just judging the appearance of the product. So first one, if you see, that's a furniture design, and the next one is a ornament design, and the third one is the shape of the pressure cooker, And these are the costume designs like sari, salwar, lehenga, shirt patterns, ornamental works, neck patterns, all these comes under the designs. So even the shapes of the bottles, if you see here, the same Dove moisturizer is available in the different shapes of the bottle. This is just to attract the consumer in that particular areas. So we have seen that patent is for the technology and design is for the appearance of the product. In order to get more number of, in order to get connect with the more number of customers, trademarks plays an important role. In simple words, trademark is a brand value. So what is trademarks means? A sign capable of distinguishing the goods and services of one enterprise from those of other enterprises. So you can see the examples here. The first one is Nike, Adidas, Puma, McDonald's, Pizza Hut, Domino's, FedEx, Blue Dart, Indian Post. All these are the trademark symbols. So what comes under trademarks is brand names, taglines, sound marks, logos. So brand names like Nike, LG, taglines like just do it, life's good, open happiness. Sound mark means, so if you open Netflix, you will be listening the tudum sound. Just by listening that, the other person will be identifying that this person has opened the Netflix. So as you're associating with that particular brand, even sound marks also comes under the trademarks. Like when you switch on the Nokia mobile phone, you will get some music. So we are associating that music with that particular brand. So sound marks comes under the trademarks. And logos like this tick mark and that LG symbol, all this comes under the trademarks. So one of the most important intellectual property from the commercial point of view is trademarks. So it's not just the name, symbol or logo, you are actually identifying the brand and you are able to distinguish the goods and services from one product to one company and the other company. So, and it allows the business entity to build a public goodwill and the brand reputation. So, and also it's like a assurance to the customers that that particular brand will have a good quality of goods and services. So if you're planning for building a startup, so it is recommended to first file for the trademarks. So how to indicate your trademark means, so if the particular company name has TM besides that, it means they have filed for the trademark. And if it has encircled R, it means it's a registered trademark. So this is simple quiz here. This is a simple crossword puzzle which has some trademarks here, which are the daily usage products. I hope you can identify them. So can you identify the brands in this crossword puzzle? Can anyone identify the brands? So I'll show the answers. So Pepsi, Amul, Tata, Dettol, Lux, Horlicks, Babool, Bata, Cadbury, Link, or the brands in this crossword puzzle. So can you identify what is wrong in these two pictures? So if you see in the first picture, the original name should be PUMA, but here it is POMA, and it should be Bisleri, but it is Bisberry. So they cannot use the original name, but they want to misguide the customers. So they slightly change the names. So now we will see copyright. So copyright is an exclusive legal right granted to creators on expression of an idea. So copyright is not for the ideas, it is for the expression of an idea. So if you take movie stories, most of the stories are related to love stories or some fraction dramas, like something like that. So how the one movie story is different from the other movie stories, how the director is expressing that particular ideas, or expressing that love story, how the conversations between the hero heroine happens, screenplay, all these comes under the copyrights. So registration is not mandatory since copyright comes into existence as soon as the work is created, but it is recommended to file for the copyright for better enforceability. So even suppose if someone take away your work, you will be having a legal proof to submit in the court, to submit as a valid proof in the court. What comes under copyrights is literary work, paintings, photographs, drawings, films, music, choreography, sculpture. All these comes under copyrights. The term of a copyright is generally if a person creates some work and publishes his work, it will be lifetime of that particular author and 60 years after his death. If a company publishes the work, the term of a copyright is from the date of publishment, it is 60 years. Next, we will see semiconductor integrated circuits layout design registry. So it is nothing but the arrangement of the components on a printed circuit board. So now we will see geographical indication. So geographical indication is a sign used on products that have a specific geographical origin and possess qualities or reputation that are due to that origin. So there are some examples like Edayur chilli, Tirupati laddu, Madalam of Palakkad, Mysore sandal soap, Kanjipuram silk, Neelambar tick, etc. So if you take the Tirupati laddu can be prepared all any way, but the particular Tirupati laddu has a unique taste. Even in the case of the Mysore sandal soaps are available in the market. Even the sandal trees or sandalwood trees are available all over the India. But Mysore sandal has unique quality and unique smell. So that's why that particular quality becomes because of that particular location, environment, and the group of people who farm these sandalwoods. So that's why the uniqueness of that particular product comes from that particular area. That's why they are called as a geographical indications, and all the geographical indications has a location name. So if you say Mysore, sandalwood particular comes from the Mysore place. That's why it is called as a Mysore sandal soap. And even the silk from Kanjipuram called as Kanjipuram silk, which has a GI tag. So these are some other examples like Dindigal locks, Kashmir saffron, Kovilpatti Kadalai Mittai, Pokkali rice, Darjeeling tea, Kodaikanal hill garlic, and the most recent one, if you have seen in the newspapers, is Kodangalur, some cucumber variety. It also got the GI tag very recently in November or December, something like that. So it's a most recent GI tag from Kerala. And these are there are some other types of IPs, that is plant varieties. So this comes under the Ministry of Agriculture. So trade secrets, you might be knowing that the recipe of the Coca-Cola, Google algorithm, KFC chicken wings recipe, all these are the trade secrets. So the particular companies doesn't disclose the recipes of those products. They simply keep it as a secret with the government. Next one is the traditional knowledge. So you might be knowing that some simple examples like turmeric. We use turmeric for health benefits, for also cosmetic product we use here in India. But the Western countries, they are not aware about this, and they start filing patents or developing these products and get the monopoly over that. So, so now a system has been developed in such a way that all these traditional knowledge are protected by under a database, so that no person will get the monopoly for the traditional knowledge, of the countries. IP everywhere. So if you see, you will be seeing a lot of different intellectual property around you, but you might be not clearly distinguishing by each one. So if you take a laptop, that particular logo, Apple logo, comes under the trademark. The shape of the laptop comes under the design. The technology inside the laptop comes under the patents. And the user manual comes under the copyrights. And the layouts, the arrangement of the components comes under the SICLD design protection. So patent is for the 20 years and design is for the 10 years. So after registering, so you will enjoy the monopoly for a period of 10 years, but you can extend it for the further 5 years. And trademark and GI are indefinite, and copyright, it is for the lifetime of the author plus 60 years, and also In case of a company, it is 60 years. So who can apply for the intellectual properties? Any person or a group of people or legal representatives on behalf of these people, or companies like startups, MSMEs, big companies. So even the legal representatives on behalf of these companies can file for the intellectual property. So patent is for the technologies, design is for the appearance of the product, and trademark is the distinctive sign for the to identify goods and services of a company. On a printed circuit board. So points to remember is first protect, then publish. So if you see, we Indians are very good at innovation and creativity work, but we fail to protect our work. We are very curious to show that in a public stages everywhere. We are very curious to show our work to the society. But before publishing your work, it is very important to protect your work. And this protection registration is done by the sovereign authority, and the rights are for the limited period of time, and all the rights are territorial in nature. There is no automatic relief. So if you think that, okay, I got the registration from government of India, so rest of the things will take care, government will take care. It is not like that. It is your responsibility. If you find any person using your work without your permission, any person using the work for a wrongful manner, in a wrongful way, so it is the responsibility for the registered person to file a case against those infringement people. So which type of, we'll take some simple quiz here, some 4 to 5 questions. If you are interested, you can answer. You can use the speaker or the chat box to answer the questions. So which type of intellectual property protects the paintings painted by the artist is, so it's an expression of an idea. So copyright protects the paintings. So what protects the intellectual property created by fashion designers? It's a registered designs. So if you want to protect your designed garments or designed ornaments, you can go for the registered designs. Which of these is a geographical indication? So as I said earlier, geographical indication starts with the name of that particular location. So here the answer is Venkatagiri Salu. So if you imagine there is a cricketer and he has set up his own company to sell the clothes. He want the public to identify the company through the clothes. So how can he use the intellectual property is he can use the trademarks. So he can use the trademarks so that a public will be able to identify his products through the brand image. If a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention? So as this is related to technology, they can protect their work through patents. So where to approach for protection is, for patents it is Kolkata, Delhi, Chennai, Mumbai. For designs it is Kolkata. And trademarks Mumbai, Delhi, Kolkata, Chennai, Ahmedabad. Geographical indication it is Chennai. SICLD it is Delhi. Copyright it is Delhi. And if you need any information related to filing procedures or the trainings related to these intellectual property, you can always approach Rajiv Gandhi National Institute of Intellectual Property and Management, which is in Nagpur. They will guide you in everything in the field of intellectual property. So now we'll see briefly how a patent is filed in India. So as I said, patent offices are available in Mumbai, Chennai, New Delhi, Kolkata. And filing procedure is either online or offline. So if you are using a legal representative, the only option is an online option. But if you are filing directly, you can either file through offline or online. So this is the ipindia.gov.in IP website by the government. So you can see the tabs here: patents, designs, trademarks, GI, RG and IPM. So you can click on each tab in order to get more information, or in order to submit your applications or anything related to these particular fields, you can click on these tabs. You will get the more information about that. So this is the e-filing portal for the patents. You have to give your login credentials and you have to submit these forms. Form 1 for the application, Form 2 is your invention. So Form 3 is for the statement of foreign filing. So Form 18 is the important one for the request for examination. And Form 5 is a declaration to inventorship. So if you are using the legal representative, Form 26 is important. So this is the fees filing for the patent. It is for Form 1 it is 1600 and for Form 18 it is 4000. So minimum fees for the patent in India is 5600. So there are some inventions that are not patentable, not protected under the patent law, like inventions which are opposite to the public morality or contrary to the public beliefs or contrary to the established laws, or some business methods, business ideas, and mathematical programs or mathematical formulas, computer programs, algorithms. All these are not patentable under Section 3 of Indian Patent Act. And even some manual for patent office practice and procedure for more information for the drafting of the patent application. So how to what is the process to get a patent means? So everything starts with an idea, not only a patent. If you take the any creations, like even the book or the painting, everything starts with an idea. So once you get an idea, you have to search in the available resources within you whether that particular idea is already available in the society or not. So if I develop a technology, if it is already there in the society, it's a waste of time for me. So and the waste of time and money to develop the same technology which is already there in the society. So similarly, if an author writes the same story already written by the other person, it's a waste of time for this particular author. So everything starts with an idea, and before proceeding to the implementation of that idea, it is very important to search in the available resources whether that particular thing is already available or not. So if you are confident enough that it is a original and new, so you can file for the draft the application, any either it may be patent application or the copyright application or trademark application. So you can draft for that application and you can file the application in the intellectual property offices, and the examiners in the intellectual property offices like patent examiners or copyright examiners, trademark examiners, they will examine your application. They will search the resources available to them, and they will decide whether it can be registered or not. So this is a sample patent certificate. These are the available databases for the patent searching. So for any information, you can click on these links. So for the information related to intellectual property, whether it can be related to drafting or whether it can be related to patents, copyrights, trademarks, and IP valuation, so IP commercialization, all this information you can get from the WIPO website, World Intellectual Property Organization. You can see that particular link here below, WIPO. So in WIPO, you can get any information related to the intellectual property. So you can get the trainings also from there. So career opportunities are, you can and you can also become a patent drafting specialist, analyst, or if you are from a law background, you can join trademark or copyright firm. So if you are from a commerce background, there is a huge importance played by these commerce students or employees there. So if you see if you take any company, intellectual property is the intangible asset to that company. So it is one of the most important thing which will decide the future of the company. So they have to value that particular intellectual property. If you take a technology, so that particular patent has to be commercialized to get the earnings. So one has to have the knowledge of commercialization of the particular technology and also the valuation. So if the companies are merging, if two companies are merging, even the IP assets are also valued at that time. And also if they are selling to the other company, if the one company is taking away the other company, this IP valuation is also very important. And also licensing, so to decide the value of the intellectual property, so in licensing, in everything, the commerce people also have the major role in the intellectual property field. So as you have given your time to listen to this session, so this certificate will be given to the students for the participants, and also we will be getting the appreciation certificate for the college. So if you have any doubts, you can ask now. If you want me to repeat any topic, you can ask. Any doubts? If there are no doubts, we can end the session also. So please confirm. If you have any doubts, you can ask. You can use the chat box also. Shall we end the session? Anyone, please confirm. Any doubts, or can we end the session? Okay, so there are no doubts or no questions. So shall we end the session now?
Okay, ma'am.
Okay.
Dear participants, the feedback form is there in the chat box. You all please fill the feedback form. Then I invite Ms. Nada for the official vote of thanks.
Good morning to one and all. I'm present over here. I feel honored and privileged to get an opportunity to propose a vote of thanks on this special occasion. I would like to thank all the honorable delegates who blessed with their presence. I'm also very much thankful all the program advisory committee members and the coordinator Rahina ma'am, principal Amira ma'am, resource person Lavanya ma'am, and all the participants. Words are not enough to thank their presence, and once again, on behalf of organizing committee, convey deep regards and hearty thanks to all. Thank you.
Thank you.
Okay, now the session is over. Thank you.